Welcome to today's Lunch and Learn panel series. It's the second in our 2025 series, and we are brought to you by Profitmaster Global Outsourcing. Let's talk about the most recent case. Are you okay to go into a little bit of detail about that, Rich? From what I know, it was a legal assistant. It was based in the Philippines. Their Australian employer, the Australian company, I suppose, to Fair Work Commission for unfair dismissal. Is that correct?
Correct. And it is really a most interesting case. It's known as Pascua. Ms. Pascua was a Filipino legal paraplanner, and she was working under an inverted commas contract with an Australian law firm. And she alleged that she was unfairly dismissed by the company that she was working with in Australia, and decided to have that tested in court. Quite interestingly, the law firm lost the case and created a number of liabilities onto itself, and then it started to be talked around the traps a little bit. And in the post-COVID environment, a lot of companies in Australia were looking at direct hire, and all of a sudden, as we're seeing now in the Philippines, particularly in financial planning, mortgage broking, and also accounting and bookkeeping, people are starting to step back and say, maybe I'm not as secure as I thought I was, and I need to have a look at this this direct hiring situation. Yeah.
So, Keeley, I'm going to bring you into this conversation as you are our legal specialist. I'm sure you're aware of the Fair Work Commission case and now a precedent, I suppose, that's been set. Is this the old contractor versus employee discussion that continues to raise its head?
I guess this Pascua case couldn't have come at a more pivotal point in Australian employment laws. It's, as many know, there's been quite a large shift in this contractor classification since August last year, and the Fair Work Act now requires constitutional corporations to apply what's called a whole relationship test. So definitely looking beyond those contractual labels to the actual practical reality of what's going on in this working relationship. So from my perspective, this case highlighted two really key questions. Firstly, what country's laws actually apply here? So Australian employment laws are only going to apply if there is a substantial connection to Australia. And that is the test that they will use in deciphering this. So without that connection, arguably the local employment laws of that worker will apply. So things that companies need to be considering first and foremost is that worker working for an Australian entity? Are they representing an Australian business? Are they using Australian systems? And I guess the second key question then goes to that contractor or employee status, which is, certainly looking at this shift in the test that the Fair Work Act now have implemented. And for any following this, there's been quite a backflip in how the courts and the commissions decipher the classification. They've gone from previously looking at just what the contract says to now looking at the practical reality and, substance over form here in terms of what that working relationship actually looks like, not just what the contract says. So, a practical example of that is going to be calling, someone a contractor, but certainly treating them like an employee. This case was absolutely a wake-up call for so many businesses around Australia using offshore workers, and it just shows that Australian employment law protections can now extend internationally. So businesses can't simply just avoid their obligations anymore by contracting offshore.
I know I've come into contact with maybe 5-6 different businesses in the last maybe 4 or 5 weeks since we've been talking about this. And depending on how they're engaged, that's a really important one, isn't it? Because it doesn't matter.
Absolutely.
What a piece of paper says, because you might have a contractor agreement, but it's going to come down to some of the key things around what deems someone to be an employee. Absolutely.
Absolutely. And that's certainly what this case highlighted, was that substance over form. It wasn't simply just because the agreement said independent contractor agreement. They really unpacked the actual characteristics of what the working relationship was like, which ultimately ended in the judgment that it did.
Yep. So are you okay to go into using your language, substance over form? Are you okay to go into a little bit of detail around what does an Australian employer that is currently choosing to engage directly, what would they need to tick off to ensure that that offshore team member was not deemed an employee?
Yeah. Well, look, I think before I go into that, I think there's another strategy that some businesses can also consider. And if they have the means to, it's considering that jurisdictional separation. So if there is an ability to engage through an offshore entity where possible, doing that, just creating that clear separation from Australian operations is always going to be beneficial. But look, if Australian law does apply, and this is where I spoke to before about that substantial connection test, just ensuring that it is a genuine contractor engagement. So this is where those August 2024 amendments to the Fair Work Act are going to be pretty critical for businesses to understand. And under that new legislation, like I said, it's the whole relationship test now. So meaning how that contract is performed matters just as much as what the contract says. And that's having alignment between what your practical reality is in the contract. And that can be things like control. So ensuring that those contractors have real autonomy over how the work is performed. That's going to be a really key factor in determining status here. And, you know, ensuring that they have meaningful autonomy over how they perform that work for whoever they're engaged by. Payment is another really big one. I'd prefer project-based fees rather than, say, hourly wages. And this was something that was heavily scrutinised in the judgment by the Deputy President, and you know, consistent with that case that Rich was talking about before, was they were naming it as wages in the contract rather than a service fee. So doing project-based fees rather than hourly wages effectively. Another thing will be, does that contractor actually bear genuine business risk? They are effectively a business after all, and most businesses carry risk with them. So can they carry risk of their own? Delegation. True contractors should absolutely have a right to delegate or subcontract out. So do they have that delegation authority? Is there clear separation from the contractor with the business? So what this judgment actually went into was the fact that the contractor was not conducting a business of her own. And that's simply what a contractor is. They're conducting their own business. So having that clear delineation, and they're not so integrated in your business. And I guess finally, another thing to consider, are they exclusively yours to engage, or do they have an ability to go and engage with other clients of their own? Do they have an ability to scale their business? Do they have a ability to have their own business structures? They're all really key things in deciphering this whole relationship test. So remembering, you know, control, payments, delegations, all of these things are going to be really helpful. But yeah, look, what's absolutely most crucial is that under these new laws, that these elements exist both in the contract and in practice. I guess for any businesses concerned about compliance, certainly using established outsourcing providers who directly employ those workers can provide that layer of protection. It certainly has that delineation between the business and the contractor for those offshore workers. So if you are considering, I guess, making changes to how work is performed, certainly consider how those changes might impact the classification of that worker under these new laws.
You may even have to get further advice, and I think that's probably a key thing. I know one of the firms I spoke to in Melbourne was exactly that. You know, he sort of hit a bit of a panic button straight away and went into, well, we need to get advice on this straight away. And I suppose that's where companies like SLF come into it, doesn't it? And
I think, Paul, just to add to that is, you know, it's not a one-size-fits-all approach at all. Different decisions that are handed down will give a really good indication based on industry or based on role. So mortgage brokers are going to look very different to another type of contractor engagement. You know, IT providers, things like that, they all have very different characteristics, and some decisions will hand down a different type of view on this whole relationship test to, say, a paralegal, which was what was discussed in this case. So certainly, if you are wanting that separate independent legal advice, seek it, because it's certainly applicable to your individual business and operations.
Yeah, and the total risk around that as well, especially if they're going to go with back payments and
Absolutely.
all that comes into it. It just changes the complexity of it dramatically.
Yeah, absolutely.
Brilliant. Rich, have you got anything else you'd like to add to that?
It was interesting that Keeley just mentioned mortgage brokers. We're actually seeing mortgage brokers coming back to us at the moment and saying, hey, listen, we're a bit worried about this direct work from home situation. We think we'd like to have people come back into the office. It's about privacy and things like that. But to go a little bit further from what Keeley was saying about the test, I think there is a movement towards this employer of record, where a company in the Philippines or anywhere else, but a company in the Philippines will actually become the employer of the now I'll use the word employee, so that there's a clear relationship between the outsourced company or the employer of record and the individual themselves. But I don't think that's actually enough, because if you're using an employer of record, what about the other parts of the tests? Who's providing the instructions? Who's providing the delegation? Who's providing the equipment? Things like the email address, the telephone. Who's providing all of that? And their part, if you get down into what Keeley's been talking about, there's some of the things that go to make the decision.
What's your advice to companies that have currently got direct hires, to how Profitmaster can help them change that?
We've been here for about 11 years now. Throughout COVID, we continued to operate during COVID, even though we sent everybody to work from home, and they worked from home for about 3 months. Now, that was the period that I mentioned we made the investment into our IT infrastructure to be able to manage this going forward. The other thing is the independence of the relationship that a company like us provides. So even though we encourage a close relationship with their client, we also encourage a very close relationship with our staff and our people here. This is a known fact that people who work in an office environment, particularly in the Philippines, where the cultural nuances of what we have here are different to Australia. The things that result in are, for example, longevity, a personal closeness, not only to their team members here, their teammates here, but also to their clients as well.
Thank you, and signing off till I see you next time. Thanks again.
Thanks, Paul. Thanks, Rich.
Bye.